Good morning, this is John Lynch of Lynch Solicitors in Clonmel on another one of our COVID-19 talks. This morning I'm going to talk to you about what I've termed the three wise men. Well, actually I'm not going to talk about the three wise men as such. I'm going to talk about the first one, which is an executor under a will. The other two, which we'll do another series of talks on, are the guardians and trustees. The first thing I suppose to highlight is exactly what an executor is, what their function is, what their duties are, and what their powers are. An executor, when somebody dies, their estate, i.e. their assets, need to be dealt with. And normally in a situation where there is a will, it's dealt with by the executor. And the executor, I'd like to put it in terms of the person who's there to execute the will or execute your wishes under the will. The executor is normally appointed under the will, and there's a couple of suggestions that at Lynch Solicitors we would suggest to you when making a will and or when nominating an executor. First of all, the number. There's no requirement as such to have any more than one executor. In fact, there's probably you can have as many as you like, subject to practical restriction, i.e. that the powers that be, the probate office, will only allow a certain number of people to take out the paperwork or to deal with the paperwork. But just back to the minimum number for a second. You can have one executor if you wish. However, practicality dictates that one leaves you in a risk situation that person may not be there when your will needs to be executed, i.e. when you pass away, they may already have predeceased you, in which case you're without an executor. Question is, what happens in that scenario? Well, what happens in that scenario is that you then have to, as in the estate, then has to go to the cost of making an application to appoint another person instead of the person that you nominated. So, to make a long story short, two is always better than one. The next question that we're often asked is, who do you appoint as an executor? Well, I think the cardinal rule is appoint someone you trust. Trust from a common garden sense, in that you trust them to carry out your instructions, look after your interests. You trust them that they know you, they know how you would want things done. Also, competence is another thing. It's good idea to have somebody who you think can manage the job. And just as an aside, as a job, it's not as straightforward as one might think, in that there are certain responsibilities that come with being an executor. But more of that later. The other thing then is, from a practical point of view, is it's always handy to have somebody who's close by to the assets to manage them, and who's local, and it's not as easy where somebody is more further removed from assets to actually act as an executor. The other question that kind of follows on from that for people is whether or not you have to act as an executor. In other words, are you obliged, if you're named under the will, to act as an executor? Are you obliged to do the job? The answer to that is no. You can do what they call renounce. That leads me on to the other suggestion that we often make when we're dealing with executors, which is to tell them. Not only should you tell them, but you should more than likely discuss if it's any kind of complication situation, or if there's any issues that you want highlighted. You should talk to the executor. So the executor should consent. By the way, as an aside, the fact that the executor consents doesn't mean, or it doesn't follow from that they must carry out their role as executors under your will. And that means that they can in fact renounce, even though they've agreed with you that they'll do it. The other thing that we will often suggest to people when they're nominating executors is even though you can nominate whoever you like as an executor, it's not a good thing to nominate a minor or somebody who's underage, because if you do that, then until they come of age, they can't actually carry out your instructions. It's also not a good idea to appoint somebody who may have capacity issues, because obviously, again, in that scenario, it may very well be that they can't carry out the instructions or can't undertake their role as an executor. The next thing that I would like to talk to you about is what are the powers of the executor. Sorry, I'm just looking down there just at my notes. What are the powers of the executors? Well, the powers of an executor come from both the Succession Act in 1965 and also under the will. The important thing to remember is that the basic powers are there in the Succession Act, i.e. that they can sell assets in order to make payments to beneficiaries. They can lease assets if they wish. They can make investments. They can do what we call appropriate an asset. And appropriating an asset means that there are certain priorities when you're dealing as an executor with an estate, in that you have to pay what they call the testamentary and funeral expenses first. So they're all the costs that are in and around burial and things and issues relating to that. The second thing is they've got to pay debts and other liabilities that might arise. So that's number two. Number three, then the legal rights or legal entitlements come into play. So if there's a spouse, if there's a legal right share, in other words, something that the spouse is automatically entitled to by law, then under those circumstances they must get paid next. And then after that, and only after that, do you pay the beneficiaries. So they're, if you like, the functions or the role of an executor. And just to stay with that for a second, I mean, the overriding kind of job that an executor has is to, number one, do what we call gather in the assets. So they have to put together what's involved, so they must know where everything is. And that gives or prompts me to the other suggestion that we'll often make to people, i.e. that you should let your executor know where everything is. So it's often the case that when you make a will with your solicitor, that you will have a schedule of assets. It's probably important that that schedule of assets should find its way to the executors as well. So if you have it in a box at home, if you have it in the bank, if you have it with your solicitors, like your will, it's important that they get a copy of that schedule of assets and also a copy of your will. And that's another point that we often make to clients, is that in Ireland, we don't have a central register for wills. So you can't find out whether somebody made a will or not until such time as you get a copy of the will or that you're told about it, or until you're notified by, say, the solicitor who's holding the will, because there isn't a central register, and that causes problems in its own right, insofar as you can often have a situation where there is a will but nobody knows where it is. Hopefully in due course that's something that will be addressed by our system in Ireland with all our modern gadgetry, particularly during COVID-19. You would imagine that that's something that should be easily enough addressed, whereby you'd make it compulsory to register a will, and that there would be a central registry system that would apply. Now, the other thing that is often asked, as well as the powers of the executor. Now, just to finish on the powers of the executor, by the way, you can add extra powers within the will to an executor. And these are often, the ones that will commonly arise is that you might give the executor power to invest, what we say, freely. In other words, that they're not limited to the type of investments that they can make. And this is particularly relevant, or can very much arise where you're talking about where an executor might also be a trustee. So in other words, that they have financial kind of requirement or financial responsibility under the will, which involves investments or making investments or managing investments. So often under the will, you might give them additional or extra powers, so that gives them wider scope in terms of the investments that they can make. The other thing that can often be the case, or can often arise, or you might often give them as an extra power, is that under the Succession Act, there are very specific requirements on appropriating assets. So in other words, taking an asset and selling it and using it to pay off various benefits under the will. Often you have to serve notice, etc. So, and do additional paperwork. Often you can bypass that. You can bypass the time limit, or you can bypass having to make or issue those notices. So that's often a power that you'll find under a will. But anyway, if we move off powers for a second and just deal with another question that can often arise, and that is the question of what's the downside to being the executor? And what, other than the practicalities of the fact that it may be quite onerous to actually carry out the functions of an executor, I suppose if you leave that downside aside for a second, that raises the question that if you are an executor and you have expenses, which, travel expenses, or, let's say you're using paperwork and you're issuing letters or emails, or you're doing anything that involves an expense or an overhead, those expenses are in fact recoverable as part and parcel of the testamentary expenses that you're entitled to deduct from the estate. But the question that we're often asked at legislators is, can you pay an executor? Can you make a payment to an executor? And the straight answer to that is that if you have what they call a charging clause in the will, you can charge a fee for acting as an executor. In fact, this is quite commonly the case where you nominate a solicitor to act as an executor, that they would input a charging clause into the will to ensure that you could be legally paid. In other words, that there would be no issue about payment. Another way of doing it, of course, is to make a bequest to an executor under will, in which case they'll benefit by way of the bequest. That kind of leads to another question that we've been asked, or that has been asked before, and that is, can you be an executor and also benefit under the will? And the straight answer to that question is yes, you can. However, you can't witness a will and take a benefit under the will at the same time. That just flows from the logical undue influence type scenario, i.e. where one would be suspicious, if you like, that if somebody witnesses a will, that it might give rise to some kind of undue persuasion or undue influence on the person making the will, and hence there is a prohibition of witnessing the will and taking a benefit. So just to clarify that, so if you witness the will, you can't take a benefit under it. If there is a benefit under it, you are disqualified from taking that benefit. So the last issue, or the last element of this that I'd like to just address, is what kind of action can you take in the context of an executor? So let's say you're a beneficiary under the will. What can you do, or what kind of control do you have over the executor? Or what can you do if the executor does nothing, or doesn't do it properly, or doesn't do it on time? Now, what you're looking at there is that you can make an application to remove an executor in circumstances where the executor isn't in fact carrying out their functions, or carrying out their functions in a way that's detrimental to the beneficiaries. You can make an application to remove, and there has been quite a number of cases in the recent past where those applications have been made. That kind of leads you on to the whole question of when and how long before you can do that. And there is what they call the executor's year, which is kind of a grace period where you can't do anything, if you like, to push an executor to carry out their responsibilities, or ask them to carry them out faster, if you know what I mean. And it's kind of a year's grace scenario where you can take action against an executor. But you can, in fact, if the executor does nothing, and there are commonly situations where estates are there and nothing is done, a will is there and nothing is done on it. And in those circumstances, you can take action as a beneficiary, or as an interested party. You can take an action against the person nominated as executor and ask them to do their job.